Continuous service under IDA 1947 Industrial Dispute Act. It is in section 25B defines continuous service for the purpose of chapter VA. A workman is said to be in a continuous service for a period if he is for that period in uninterpreted service, including service which may be interpreted or account of sickness or authorized leave or an accident or a strike which is not illegal or a lockout or a cessation of a work which is not due to any fault on the part of the workman. So this is the continuous service which is explained in section 25B of IDA 1947. Then layoff. It is in under Industrial Dispute Act 1947. Layoff is mentioned in section 2 clause KK. It defines a layoff as follows. A layoff means the inability of an employer on account of shortage of a coal, power or a raw material or the accumulation of stock or the breakdown of machinery or for any other reason to give employment to a workman whose name is borne on the muster roll of his industrial establishment and who has not been retrenched. This is about the layoff. It is explained in section 2 clause KK. Then wages. Now here the wages what includes under the Employees Compensation Act 1923 it is asked. So the term wages is defined to include any privilege or benefit which is capable of being estimated in money. It is defined in section 2 clause 1 clause M of the Employees Compensation Act 1923. The following items are however expressly excluded from the scope of the word wages. These are excluded: travelling allowance or the value of any travelling concession, a contribution paid by the employer towards any pension or provident fund, and a sum paid to an employee to cover any special expenses entitled on him by the nature of his employment. Next, what is the period of limitation for filing a claim? Under EC Act means Employees Compensation Act. So on the point of limitation, the learned counsel submitted that whether the claim application of the claimants under the Workmen's Compensation Act was barred by limitation as it is filed 2 years after the date of the accident. Then under section 10 of the WC Act, 2 years is the limitation to file the application from the date of the accident. So 2 years is the limitation for filing a claim under EC Act. Then define commissioner and seaman under EC Act. Commissioner explained in section 2 clause 1 clause B of the Employee Compensation Act. A commissioner means a commissioner for employees compensation appointed under section 20. And seaman, it is explained in section 2 clause 1 clause K of the Act. It means any person forming the part of a crew of any ship but does not include the master of the ship. This is the seaman and commissioner under the EC Act.